Hi, I'm Trisha Dunlap with Dunlap Law, a small business law firm in Richmond, Virginia. I'm here today to talk with you about something that's been pretty hyped in the news lately, and if you're a business owner, you might even be a little freaked out about it. And that's the idea that your business might be sued by a member of the public who comes into your retail store or your restaurant or maybe your office building, and they get coronavirus and then they sue you alleging that they got the virus at your establishment. There's been a lot of news coverage, and I'm here to tell you that that's going to be a harder case to win than the news makes it seem. So let's talk a little bit about that. First of all, any plaintiff is going to have to show, number one, that they got the virus at your establishment and not somewhere else. That's going to be really hard to show because the virus is everywhere. How can they possibly prove that they picked it up at your restaurant or your retail store or your office building rather than, say, at the grocery store or at the beach or wherever else they might have been? Number two, they're going to have to show that you were negligent. And what that means is that you either did something you shouldn't have done or you failed to do something that you should have done. And that a reasonable person would have done these things or would have not done these things, depending on whether it's an act that somebody did that was negligent or a failure to act that was negligent. Either one of those could be negligence. In my earlier videos, I urged business owners to really carefully consider their operations and how they're running their business before they reopen. If you have fully evaluated all of your operations, your policies, your day-to-day practices, and then amended those so that they're aligned with CDC and health department guidelines, then you've taken the first few steps towards showing that you have taken the actions a reasonable person would have taken to reduce the risk. It's important that you continue to track CDC and health department guidelines so that if those change, you can revise your business practices accordingly. Those are the things that you can do to show that you've taken reasonable steps to mitigate the risk of the virus, and it will help protect you against any kind of claim that might be made. You could also document this. So you can document the date that you pulled down CDC guidance off of their website, and then document all of the steps that you took to change your business practices so that they aligned with CDC guidelines. Keep a file for all of that. And then as you revisit all of these CDC Health Department guidelines and perhaps change your operations and your practices, continue to document that so that you build the file as you go along. That'll show that you're diligent. Those are the two things that a plaintiff would have to show. But even if you did get sued and needed to defend yourself, there's an argument that you can make that could help you win the lawsuit. And in Virginia, at least, it's a get out of jail free card. It's called contributory negligence. And here's how it works. Let's pretend that I'm driving down the street and I misjudge the space of a merge and I hit another car. Well, I'm at fault for that. I'm negligent for that. But let's say the other driver was looking down at her phone and she was texting. Well, she's also at fault for it, right? She contributed to her own harm. That's contributory negligence. In Virginia, unlike most states, this knocks out a plaintiff's case completely. If a plaintiff contributed to their own harm in Virginia, they're done. Go home. In other states, it's not quite that simple. Typically, they will divide up the amount of harm. How much of the harm was caused by the defendant, how much was caused by the plaintiff. But in Virginia, it's a knockout. So you could easily argue that a person who got coronavirus got it because they were at the Virginia Beach boardwalk without a mask, having a good time. Or maybe they were at an open air party with 50 other people and didn't have a mask on. Maybe they took part in the protests that we've seen recently without a mask. And you know all of this because it's all over their social media. That could easily give you an argument that they contributed to their own harm and they're also negligent. So these are three things that you can perhaps think about and give yourself a little peace of mind that a claim against your business is going to be harder to win than it might appear. I hope this video has been helpful. If so, please like and share it. Subscribe. I'm doing these videos about once a week on a variety of topics. And if you have a question, comment down below. Thanks very much. I'm Trisha Dunlap with Dunlap Law in Richmond, Virginia.